Right, hello and welcome to the No State Project Reloaded. We are the UK version of the No State Project, Mark Stevens' child, if you like, and welcome to the show. It's the 10th of March 2013, and I'd like to welcome on the show with me today, we've got a few callers in. I've got Helen, Paul,
hey there.
Fabrice, hello there.
Hi there, Vin.
All right, and who else has joined us? We might have a couple of others in there, but anyway, if anyone else would like to call into the show, they can contact us on Autonomist123. That's on Skype, and if I can get the number up later, there's a number you can actually call as well via Skype. If you'd like to call into the show at all with any issues you're dealing with, bureaucratic tax and that, we're more than welcome to take your call. But I'll get straight back to the guests I've got on today. Thank you ever so much, everyone, for coming on the show again and sharing your stories and that. I'll turn to Helen first, if you like. We've got Paul with us, who's got a case coming up next week. We're going to talk a little more about that. And I'd like to talk to Helen.
Hey there.
Hello, Helen. You was in court last week, wasn't you?
Monday, yeah.
Right, so you was on Marc's show last night. Obviously, if people have heard the Reloaded show just before this, they'd obviously hopefully have heard what you was talking about. But
yeah,
if you want to just give us a quick overview, what happened and what you're planning on doing next.
Yeah, sure. It was a plea hearing for a speeding offence for going 36 miles an hour on a road, and someone said I shouldn't do that, so they sent me a letter asking me to plea. I couldn't do that because I didn't know I'd committed a crime. So we went to court and they tried to get me to plea. And again, I couldn't plea. I wasn't refusing to plea. I was asking for more information before I could plea. And the main information we were asking for was evidence that the Road Traffic Act is applicable to me. And we asked before we went to court and they couldn't provide it, and we asked in court and the magistrate got a bit hot under the collar, said a few stupid things, and in the end the court entered a plea on my behalf, which we'll apply to have dismissed. They've agreed to hear my application for dismissal of the whole case at the beginning of the next hearing, which is scheduled for the 18th.
Right, okay. But that's when I was saying, I believe, I remember you talking to Marc where she said that, that you'll be coming to that hearing so they can look to set in a date for trial. But I think this is where you maybe have to be careful, because sometimes this is when they say, okay, I tell you what, we're going to go to trial right now.
I think it is the trial that day. Personally, I'm going to go with that. But I haven't had the paperwork through yet. They haven't managed to get it to me yet, so I'm not totally sure. Mm-hmm. And we have tried to ring the Crown prosecution to get the evidence we've been asking for since before the plea hearing. But Wednesday they didn't have the file, and so she told me to ring back Friday, and then she didn't take my call on Friday. She wasn't available. I left a number. She didn't get back to me. So we're going to try again tomorrow.
Yeah. So, I mean, when you was talking to Marc, I know he mentioned that you could actually put a notice in or an application to have the case dismissed on the grounds of abuse of process, where the magistrate has basically committed gross misconduct or misconduct on the grounds that she claimed that she could gain jurisdiction over you.
We're going to work on what it's going to be is a supplication to the application to dismiss that's already in, because they've already agreed to hear that. So I don't want to pull it out and put another one in. I just want to do a supplication to it, adding all the stuff that Marc suggested. So we're going to try and get that in tomorrow or the next day.
Yeah, that'd be good. It's going to be interesting to see where this leads to. I mean, if you do end up having that hearing it, or it doesn't get adjourned or put back to another date, I'll certainly try and make it down myself. And,
you said you'd come down.
I'll come in next.
And I've got Fabrice there as my Mackenzie friend, who's been amazing, and I've learned all this because he's helped me and role played with me and drilled it into me. So having people there to support you is really important. I had a few people in the public gallery as well, so that I wasn't outnumbered by them.
Yeah, it does help, and we do encourage people as best they can, even if they're not using Marc's methods as such. Try and always take people in there to witness what these judges and that are doing. I wouldn't say it gets them nervous. It should get them nervous to the point of they should be acting on better behaviour.
Yeah, if they've got nothing to hide, they've got nothing to feel nervous about, have they? Because we're not challenging them in any way. We're just asking for them to provide the evidence, which is their burden of proof.
Mm-hmm. Yeah, I mean, can you just tell us again what some of the more outrageous things the judge said? Yeah, or the magistrate, sorry.
Yeah, sure. I'll just flip through the transcript here and get a few. Well, when they tried to proceed, and I objected right at the beginning and said, I don't see how we can be ready to proceed. I've requested evidence for the prosecution that hasn't been forthcoming, and I have an application in to dismiss. So at that point, they took a few minutes out to have a look at the letters I'd been writing, because obviously they'd come there and nobody's seen anything. She came back in and she said, we are at a loss to understand what is going on here. So that was quite a good start. And then she said, you're alleging injury in your letters. There is no injury. There is no injury. Whereas we know that for any charge to stand, there has to be an adversary. There has to be some kind of injured party. And so by the magistrate saying there is no injury, she's really invalidating the charge.
Absolutely, yeah. It's called an injury et damnum. Yeah.
Yeah. She then moves to dismiss to put in a plea on my behalf, and I object. And where are we? Yeah. And then I challenge that she can put in a plea in my behalf as she established jurisdiction over me. Well, I just ask her if she has. I'm not challenging. And she says, are you challenging court jurisdiction in this matter? And I just said, no, I'm asking for the evidence that you've got it, and that there is a case for me to answer to. And then she confers with a legal clerk again. And I'm not going to repeat everything I said on Marc's, because some people will have heard it earlier. So let's move through to the really silly bits. Oh, the legal clerk says the bench represents me. Really, I should have looked shocked and said, wow, a bench can represent me.
Bit of wood, yeah.
What she's saying is they can represent me when I refuse to plea, and so I was making it clear I'm not refusing to enter a plea. I just want you to answer my questions before I feel able to do that. Yeah, and so then they say, well, they can't give me any evidence because they haven't got a court file until I plead not guilty. So that's why they enter it in. And then, then I object when she does finally say, yes, we're definitely entering a plea. And she comes back with, you can't object to the decision is made. You're not at liberty to interrupt against that. And then she goes into threatening me about the costs. I should warn you, you should be made aware that by entering a plea of not guilty, attracts a reduction in the market purse. And if you enter a guilty plea at a later time, that would be directed again. She's basically threatening me that if I continue this process, it's going to cost me a lot more money.
Yeah.
At which
it's a direct. Yeah, I mean, it's a direct threat. I've had this myself when I went to court myself years back when I first got my speeding appeal. When I went to the offices, down at the court, and I had this office clerk say to me, "If you dare come in here and challenge this alleged, this speeding ticket, you're going to get everything you deserve."
Yeah.
Just
I went back to, my intention is to plead guilty. I'm just asking for the evidence, of the act that I violated is applicable to me. And if you can show me that it is, I intend to plead guilty. So for me, I don't believe that I refused to enter a plea. I never did refuse to enter a plea. So I don't see how they got any jurisdiction over me. So I asked her, how can you make a plea on my behalf if you don't represent me? And her reply was, I've already done that. Very smugly, I have to say as well. That was the only time she sounded smug. I've done it. I said, how can you? I just want to understand how you can without representing me. And her answer was, it's not for this court to be spending time on. So then I asked, on whose behalf is the plea being entered? And she replied, I had to ask her twice, and then she replied, it's entered on your behalf. So I asked her, can you enter a plea on my behalf if you don't represent me? And she said, that is within our power. So I asked her who she represented, and she said she represented the Crown. So I asked who the prosecution represented, and And she tried to end there. She said, will you please just listen? We've set your court date for the 18th of March. You're not entering a plea today. The Crown will enter a plea on your behalf and you'll be there at 10 o'clock. So I asked her again, so no pleas being entered today. And she keeps repeating the trial. And then she said, so I asked her, can the prosecution be ready to proceed if they haven't provided the evidence against me? And she said, yes, it's for the Crown to decide and to set a second trial date. So I think she means the second one from the plea hearing. I think that's what she means.
Yeah.
And then I asked her, do you have the discretion to do this to me, absence of proof of subject matter jurisdiction in this case? To which she responded, I do. Yes, I do. And I couldn't quite believe she said that she could have jurisdiction without any evidence. So I asked her again, and she said, we do have jurisdiction. And then she said, and I asked her again, she says, yes, do you understand? So I said, no, I don't understand how you've got jurisdiction over me. And she's just like, we do have jurisdiction. I say, you're telling me that, but you're not showing me any evidence. Can you show me the evidence you have jurisdiction over me? And at which point she ends the proceedings and the usher tells me I have to leave. And the last word was me saying, so no plea will be entered on my behalf then. That was how it went, really. So we're back on the 18th. Well, we tried to contact the Crown prosecution, like I said before, and we're waiting to hassle them a bit before we go back on the 18th.
Right, okay. Yeah, so, I mean, we've been talking about this for a few hours now on a separate call, and something's come up earlier about the case law we're going to start using against them. And I've actually found that bit of case law we were talking about. This regarding adversarial proceedings, because as she was saying to you, you know, she's claiming there is no injured party. Well,
yeah,
if there's
says
no
it
injured
clearly
party,
twice. Yeah.
Well,
I think it's because she doesn't know what she's talking about,
so,
and she's thinking about a physical injury, because these magistrates aren't legally trained. I think she's talking about physical injury, but she doesn't realise what she's saying in the courtroom. There is no injury. There is no injury. It means there's no case.
It's a legal term. It means all forms of harm, loss, or injury. It doesn't have to be physical. An injury in legal land can be, just financial loss, whether real or not, sort of thing. An injury can be abstract or abstract and subjective. It can just simply exist in your head. You've just got to prove you've got a strong enough case to get compensation for it, sort of thing. So that's what it means in La La Land. Jockney, I've got someone I think wants to join the call. I'll find out in a minute who that was. So bear with me. But anyway, that's what I was saying. So the fact is that it's clear either way. It can't be adversarial, and if they're going to claim that, and I'll read this bit of case law out. I've just found it. It's Jasper versus the United Kingdom. Rowan Davis versus United Kingdom, and I think that it's cited under those two cases, but it's Jasper versus the United Kingdom, and it states here the court recognised that it was a fundamental. See, here's the thing. I'll read this out slowly. It was a fundamental aspect of the right to a fair trial of criminal proceedings, including the elements of such proceedings which relate to the procedure, should be adversarial, and that there should be equality of arms between the prosecution and defence. The right to an adversarial trial means, they're claiming you have a right to an adversarial trial, means that in a criminal case that both prosecution and defence must be given the opportunity to have knowledge of and to comment on the observations filed and the evidence adduced by the other party. In addition, Article 6 of the Human Rights Act requires that indeed does English law, that the prosecution authorities should disclose to the defence all material evidence in their possession for or against the accused. Now the thing is with the elements, what they're actually saying is that all of the elements are adversarial as well.
Right, so every element of the charge is adversarial.
Is adversarial, which means it can be challenged. You have to be allowed to challenge every single because every element, if adversarial, every element must show the violation of a legal right, or it must lead to that conclusion.
And we've been requesting evidence since before the plea hearing, so
exactly, yeah. So that's one case there where actually claiming you actually have a right to an adversarial hearing. It's not an issue of saying it's adversarial just because courts say that. Apparently, it's a legal right.
Good.
So there you go. So, and there was another case that we were talking about before. I've got a book called Abuse of Process. It's by Colin Wells, and it's the first edition. There's a second edition out now, which when I get some pennies, I'll try and buy the newer edition. But there's a case that we was reading out here, and it was R versus HNC, and it's got fairness ordinarily requires that any material held by the prosecution which weakens its case or strengthens that of the defendant, if not relied on as part of the formal case against the defendant, should be disclosed to the defence. Bitter experience has shown that miscarriages of justice occur where such material is withheld from disclosure. The golden rule is that the full disclosure of such material should be made. So the thing is, what that means is that they can't just be looking or presenting evidence of guilt. They have to present evidence that potentially shows that you could be innocent as well. It means it has to be an open investigation. It can't just be one-sided.
Which means they are required to show the evidence that the Road Traffic Act is applicable.
Exactly, yeah. And if they find evidence or they have got no evidence to prove that actually, they don't have a case against you, well, then they have to disclose that according to that ruling. So, and this is not what they're doing. They're only trying to put across evidence, or at least opinions that prove you guilty. But they're meant to be presenting evidence that might actually show you to be innocent as well, and that could simply just mean they've not been able to produce any evidence, and that should be enough. And that is what a magistrate or any judge should be considering. Also, it's meant to be an equal balance between the two. What evidence have you shown that they could possibly be innocent, along with evidence of possible guilt? So this is what these people are playing at, and this is where it all gets twisted in their minds as to how they're meant to actually view this. And it goes to prove that a judge can't be the impartial, fair, judges they claim to be, because the prosecution only ever acts as if, only ever want to present a case to prove you guilty, and ignore evidence that would prove otherwise. And it's all the magistrate is looking for as well. They don't turn around to the prosecution and actually start challenging them on the grounds of what other evidence have you got that actually might prove this person innocent. Have you got any? Well, no. But that's the thing, that they just want to go by the evidence that's being put in front of them, not the evidence that isn't there. They're not taking notice of what isn't there, and what isn't there is just as important as what is a lot of the time. In fact, usually even more so.
Yeah, so their system's all backwards, isn't it? Because they're forcing a plea, they're putting in a plea on your behalf before they've even established a valid charge. So
that's right. Yeah,
why should you have to plead to something that hasn't been proven?
Yeah, they haven't even established that the prosecution has even got a case. It's like we were saying earlier. It's like being accused of stealing somebody's car. That person just run into the court and saying that bloke nicked my car, and they go, "Oh, all right, pipe his feet in here, then we'll have him on a trial next week." But then when it gets to the trial and you question the bloke on it, and it turns out he never had a car to begin with. He can't prove he owned one. And it's like, well, you people have dragged me in here and wasted me time doing this. Shouldn't you have found out beforehand that this bloke actually had a car he could prove was nicked to begin with? Then he had a proper case to be to be answered to, and that's the way it's meant to work. And the police are meant to be just as liable as anybody else to prove the case. You'll always find this whenever you bring a case against the court official, even against a bank, if you count a claim or anything like that, they start asking you for evidence and proof. And if you can't produce anything, they throw exactly the same issues at you.
Yeah.
And 9 times out of 10, they'll turn. I mean, I've read. I was going through the Bailey website the other day. The amount of cases I found where appeals were being thrown out, and the first thing they were saying was failure to state a valid cause of action, or this claim does not give rise to a cause of action. That was and I read dozens of cases like that. There's probably millions, thousands like that all over the databases. So this is the same stuff they would use against us, and we're just using it back against them. Yeah. But somehow it doesn't apply to them because they put themselves in a position of, well, we're the government. We're absolutely correct. Nothing we say can possibly be wrong. We make the bloody rules. How could we be wrong? Sort of thing. But that's their attitude, isn't it?
Yeah, well, it's like something Marc said on a call the other day. It's like, say if I wrote down Vin James has to do X, Y, Z, and then you didn't do X, Y, Z, and I take you to court because you didn't do X, Y, Z. The first thing you're going to say is prove that I had to. Prove that what you wrote down is applicable to me.
Well, that's it. The analogy I use is simply state to them, if I slap a Bible down in front of you and claim that Bible says you're a Christian, therefore you are, does that make it so?
Yeah.
And it's like, would anyone just bend over and accept that, or would they turn around and say, well, actually, I couldn't care less what it says in a book. Can you prove that applies to me first? That book's got anything to do with me first. Well, it's just so in a book. I couldn't care less what it says. Show it applies to me first, then you can read from it to your heart's content. There's different analogies we can use, but it all makes, it all comes around to the same thing. It's like somebody building a church and stating, right, within 50 miles, everybody who lives within a 50-mile radius of this church is now a Christian. They've got to come and pay us money. And if they don't, we're going to punish them for it. Just based on nothing more than you build a church and declare yourself Christian, label yourself, or, label yourself whatever religion you like. That's basically what they're doing, but there's no foundation to it. But,
if they had the evidence, we'd have seen it by now, wouldn't we?
That's absolutely, yeah. And they know
we'd be guilty, and we'd have to deal with that, but they don't seem to have any evidence.
Well, that's the thing. I mean, that's what Marc was talking about before. We have to if we're going to look at this from a scientific point of view, we have to accept there could be a possibility, no matter how remote, that they could or may be able to actually come up with some evidence one day.
Yeah.
We've always got to keep an open mind, and that's it. But I mean, using the scientific method we've used, I mean, they can't prove. We can factually prove law comes from people's minds. It doesn't come from anywhere else. It's not a supernatural phenomena. It simply comes from in somebody's head. It's subjective.
It's opinion.
We can prove that on an objective and empirical level as such. And it's one of those things of, fair enough. You've got to still keep an open mind to that. It could be something else. Maybe God will turn up one day and say, "Oh, there you go. See, had you lot fooled all along. I was here all the time," sort of thing. Fair enough. If you're going to look at it that way, you have to leave that possibility open. But so far, that's the best we can do, and that's what the evidence shows us. Let the evidence speak what the evidence says. So there you have it. But I mean, I think you did a really good job. Marc was impressed. I was impressed. You did a really good job at that day, especially being your first time in court. And the stuff you got her to admit. I mean, this is what it's all about. It's all about getting them to hang themselves, and you gave them plenty of rope on that occasion. So you did really well.
Yeah, so just gotta keep it up now.
Yeah, that's it. We're doing these calls every day now. We're enjoying them. We're all learning stuff. I mean, we're all starting. It's all getting the grey matter ticking over in it, and we're all coming up with new ideas and ways of dealing with this and that. So it's
great to get so much support.
Yeah, I'd like to bring Fabrice and Paul in. If you both want to come in.
Hi there, Vin. Hi, Vin.
You're all right.
Hi, Fabrice.
All right. I'll jump on Paul first. You're going to court on Wednesday, aren't you? Next week.
That's right, Vin. I did a plea hearing last month. A little, not quite as much backbone as Helen, to be honest. I went up there on my own, and I got a couple of questions in, but there's a clerk and a judge, and they threw me a little bit. But I did get an admission from the judge that I was presumed innocent, which we've since used in some calls that we made to CPS, which are interesting. And I'll edit all that together after this hearing, and we'll see where it takes us, because it's a bit of trial and error. It's slightly different in the UK, isn't it, Vin?
Yeah, that's it. It's something we've been working on. Us three and a few others. We've been working on how we go about actually dealing with plea hearings in this country, because even though Marc's stuff is just as relevant over here, in terms of all those questions. It appears over in this country with a plea hearing, in as opposed to America, where they have what's called an arraignment. With an arraignment, it can go straight from that into a trial.
That's it.
far as I
Yeah.
know,
So they space them out here, and the staff at the court, as Helen found out, they're convinced, they've been told that anybody that walks in, that they can, the bits of paper, so they believe that they don't have to prove anything because it's their job. Whereas Marc deals mainly with the police officers and the judge as well. Yeah. But if our tickets, mine and Helen's, are very similar. The car's accused of speeding, and we own the car, so it's kind of, they jump up so many different levels. There's no actual policeman, we don't think, that's accused. Well, it's accused me anyway. He's just accused the car, and the other thing I'm accused of is not returning the letter. Of course, he can't prove that either. So it's quite an interesting little learning curve. So yeah, Wednesday.
Yeah. I'm going to try and come up and be with you that day. I'll act as a Mackenzie friend with you, and we'll give them AiLL basically. We'll see how it turns out.
Or they might. So Marc gave a guy a call last week. They might treat this one a bit more cautiously. I can see they've already made a few errors. Even if I was going to treat it the proper way. So yeah, it's going to be quite interesting.
Yeah, that's it. We found a lot of mistakes in their paperwork, and it's all little things we can use against them, regardless of using Marc's stuff as well. So we're just going to see how it pans out on that. So
someone's just asked you, Vin, what a Mackenzie friend is.
A Mackenzie friend is someone who can only act as a lay advisor. They're not allowed to address the court. They have no legal standing in the court. But it's somebody that can just simply act as a moral support or give advice. But they're not allowed to give. They're not allowed to represent or act on behalf of the defendant. So that's basically it. But they are allowed to consult and ask, and they are allowed to consult with the defendant during the hearing. But that's all a Mackenzie friend basically is.
Yeah, Fabrice did a little bit of work. Are you there? Is Fabrice on with us?
Yep.
Yes, I'm with you.
Yeah, you could explain Mackenzie friend. Where did it come from? Do you know?
I think it was originally used. I think it's been around. I believe since just after the Second World War. I'm not quite sure. It may have first been used in America, but it was just where people would have difficulty dealing with the arena of a courtroom.
Psychopaths.
Yeah, dealing with the psychopaths in the courtroom. Yeah, and it's I believe it's at the judge's discretion. So it's not a hard and fast thing, but where the legal system requires not just justice to be done, but to be seen to be done, generally they'd need a pretty good excuse for you not to have a Mackenzie friend. On some occasions, and on a couple of occasions, I know people have put in papers from their doctors. Sometimes, more often than not, unfortunately, these are generally overruled. But a Mackenzie friend can speak in court on somebody's behalf, but that's usually done with medical background and usually done well ahead of time and approved by the court before. Otherwise, they'll just let a Mackenzie friend go in and sit next to you, and you can talk to them.
You can hold my hand, Vin. Take me through.
Yeah.
No, I think you'll be able to pass notes. We'll get a big black marker pen, and you can write some big things in there. If it comes to that, though. So
when I put in as a Mackenzie friend, I find it's useful to have identical files or identical notes. So your Mackenzie friend, while you're engaging with the magistrate and the prosecution, a Mackenzie friend can help by taking notes and sometimes point you to a piece on your script or of an issue that you might wish to address at that time.
Because you do. I took a big file and I stood the plea hearing, and I was rustling through it and trying to look competent as well. And it's that's even someone just to pass you the papers is it's a big help because it's quite nerve wracking. I mean, Helen was little bit nervous, but she did a lot better than I did. My magistrate was a little bit more well behaved. She didn't make any outrageous claims or anything like that. So
it's something Marc mentions, and he's done some very good shows with Alistair Kinnear, which I think you can probably get from the No State Project archives, where they talk about neuro-linguistic programming, that the fact that the judge or the magistrate is sat 2 or 3 feet higher than you are.
Yeah.
The fact that you're given instructions at various times, and it's far subtler. If you don't get the instruction at a specific time, they will look down on you as if you're a little bit silly. They will try and use, as they did with Helen, the CPS, when they go in on a charge like this, the prosecutor has not seen the file, has not done any investigation. It's really quite sad.
We are learning that, aren't we? Hey, yeah, Vin, do you want some callers to jump in, Vin? Because we can stand here and help them out if we can. There's a few callers. I'm just reading at the screen there.
If they wish to come in on Skype, they can contact I believe they can ring this via Skype. It's 0161 298 0928, or you can contact me on Autonomist123 on Skype. So this is a No State Project Reloaded, Sunday the 10th of March. So welcome to the show, and thanks for staying with us still. Has anyone new come into the call? Is that maybe?
No, it looks like it's just us at the moment.
Yeah, I'll say if anybody would like to call into the show, just contact me on Autonomist123, and I'll do my best to try and add you over to the show. There's a chap called. Give me a second. There's a chap called Jockey, I believe, trying to contact me.
Should we talk a little bit about the role playing, which is really useful for anybody who is going into a court situation or a hearing situation? And there's been
absolutely, yeah. We've been doing quite a few of these this week, and we usually help out people in America more than anything when we do these role plays. So we're a little bit more familiar with the American system as well regarding a lot of this stuff. But we get more and more English, or people from our neck of the woods, or our side of the pond, as they say. We're starting to get more and more people over here doing these role plays. They really do help. And the thing is, we're obviously learning from each other how we're able to deal with these things in court, because what we're finding is these courts do act, especially with plea hearings, they do seem to be acting much the same way all the time. They treat a plea hearing as you're simply there to give a plea, nothing else. This court has got nothing else it can possibly do except take your plea.
I think it's someone who's trying to join, but when they try, all we get is football or something. But there is a new caller on called Weedman.
Oh, right. Okay. Yeah, I was talking to him last week. We were going to get together, and I was helping him out on a case. So are you there, mate? You can jump in any time you like.
Hello, mate. Yeah, I'm here. I'm just trying to get so I can hear you properly.
Oh, right. Okay. Is there anything new you want to share with us from what we talked about last week?
Well, yeah. There's. I'm just trying to turn the radio off so I ain't got an echo.
Oh, okay. Yeah. That'll happen.
Yeah. Well, the police came round. Well, the police phoned me. I was supposed to go back to the police station on Tuesday, and they phoned me up on Monday saying that they postponed my bail for 31 days, basically, till 4th of April. And yesterday while I was out, the police came round, but I have no idea why they came round. So I'm yet to wait. I'm yet to find out. I've no idea how it's going so far. I'm pretty much left in the dark with it.
Right, yeah. We were going to do a phone call, weren't we?
Yeah, it's just never happened this week.
Yeah, I've just been up to my eyeballs in it. I've been to a couple of court cases myself this week, and I've just been tied up with so much stuff. We never got around to doing it, unfortunately. But we'll have a go Monday if you like. If you're free, we'll give them a call and we'll see what what information we can get out of them regarding this.
Yeah, that sounds great to me. It'd be much appreciated.
Yeah, that's all right. Well, I'm helping out Paul Monday when I'm going to make a call to the Sheffield Police again to deal with the witness situation he's got for his particular case. And once I'm done with that, I'll get back to you and we'll make a call for you as well.
Yeah, that sounds good. I spoke to the police and he told me to phone a 101 number and ask for I've got it written down somewhere, but I don't know where. It's on a piece of paper. I'll find it out for Monday.
That's right. Yeah. So, have you looked any more into this stuff in terms of how you're going to go about questioning them if you go to court?
In some ways, I've been told that someone's informed me that I'll perhaps be mens rea.
Well, the mens rea can be brought up. They claim that is elements of the allegations, but the truth is they're simply just elements of the accusation, not necessarily elements of the actual crime itself, because it's only an element in the sense of what I found the weeds in your house, the plants in your house. So they can show that you committed the act as such. That's the act as rea settled. The mens rea is another issue because then they claim, well, we can prove that you intended. Now this is where it gets tricky. They obviously can't prove you intended to do anything to these plants or how you're using them. All they can prove is that you've got them and you were growing them. In that sense, at most, all they can actually prove is that they're in your house.
Yeah, that's true.
So that's it. But in terms of then what your intentions were, that's all subjective. That's all just speculation. So they can't actually fulfil that part of it. But regardless of that, one of the main elements is obviously this is a statutory offence they're bringing against you. One of the elements is they have to prove the applicability of the law, and obviously by you having those plants in your house, whether you intended to supply them or not, they have to show. So they can't bring a charge against you based on something they think you might do, and then somehow prove that's violated somebody's rights. How can you violate somebody's rights based on something you might do? It's ridiculous.
Well, yeah, to commit a crime, I thought there's got to be a victim, and I've not done anything to anybody.
Yeah, and they can't say, with intent to supply or something like that. Well, unless you can actually prove that I've supplied something, can you still then prove that there's a victim? Because if you've supplied it to somebody, have you stuck a gun to somebody's head and forced them to take these plants from you? Well, of course not. It was a voluntary transaction, very likely, but they view that as a crime, whereas the actual definition of a crime is an involuntary human relationship. So where's the involuntary relationship on your part? There isn't one.
Yeah.
The only involuntary relationship taking part is the one they're having, the one they've now got with you.
It's no different to a traffic camera ticket, really. The games that they play, what will happen is they'll put a series of events together in an order that fits a few statutes, and the solicitor will stand there and he'll explain it to the judge in a structured way, and it'll fit a little jigsaw. And what Vin and I am learning is a way to just to break that down. So you've got to do a little bit of homework, but it's no different, is it, Vin, to a traffic ticket, really?
That's right. Same issues apply regardless. It doesn't matter what you're being accused of, whether it's dropping a sweet wrapper in the street or genocide. You still have to lay out the case the same way and show the same elements. And you have to have facts proving those elements.
So
Everything counts.
Unless there's no evidence of a complaining party, the prosecution can never prove jurisdiction, and that's as far as I've seen. So, if you want to put whatever you want to put in your cigarettes, or you want to drive at any speed, as long as you're not causing, as you said, damage or injury, then there's no evidence that they can put up. There's no evidence the prosecution can provide that you've broken any law.
Mm-hmm. That's right. That's absolutely right. And it simply comes down to that. The reason is there has to be a victim, or you just don't have a case. You can't justify the case. It can't be based merely on you disobeyed us. You disobeyed and broke this act. Because disobedience simply leaves you at the will and opinion of somebody else. That's called slavery in anybody else's book.
Yeah,
and the courts have actually ruled on that as well. There's a court case we was talking about earlier. If I can dig it out again, I'll bring it up. There's a court case from the United States Supreme Court regarding this issue, and I'll read it out. So I've used it in a document myself, for fighting parking tickets and other things. I'll read this out a minute. Give me a sec. I just need to. If you could take over for me, Fabrice, a minute, because I've just got to take your mic off a minute to do something on my computer.
Certainly, no problem. And the hard part, Weedman, is when you've established, when you've got it clear in your own mind that, okay, I want this evidence from the prosecution, I want this evidence for this law that says I have to smoke these cigarettes and not these cigarettes. I want facts that it applies to me. Is that they try so many different ways to evade that and threaten you and to knock you off course, that actually it's quite difficult to keep them pinned down, which is why when we mentioned role play earlier, the more you can do that, the greater agility you have at being able to say, you know, that when they're using circular logic, when they're saying, well, just because you happen to be here, this applies to you. And you're able to show the fallacies of that, rather like Vin was saying, you know, how does this book, this Bible, say that you're a Christian? How does that make you a Christian?
Yeah, that's it. Sorry, mate. I've got that fixed. My computer ain't going to run out of juice now, so I'm safe. But,
just to let you know, James is back.
Sorry.
The caller, Law James, is back, and he can unmute now whenever you're ready for him.
Okay, no worries. Yep. Well, I'll just read this out. It's got what the American Supreme Court stated. Yip Quo versus Hopkins. It says for the very idea that one man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems intolerable in any country where freedom prevails as being the essence of slavery itself. So what that basically means is if they're simply going to just accuse you of disobeying the law or disobeying them, you know, the bureaucrats, you disobeyed us, well, then that's simply being held to the will and opinion of another. And like I say, it's called slavery. They're meant to have abolished it. So in order to justify bringing a claim against somebody under their rules and regulations, there has to be a victim. And this is why they state injury et damnum has to be present within a valid claim, a valid cause of action, or a specific cause of action, otherwise known as a charge, a criminal charge. So there you have it.
And I was just going to say, you know, I've heard some people, when they try and understand this technique of defending yourself, they think you're bringing the entire system into disrepute. And the thing is, if you put up an adversary, if I take something of yours, Vin, or if I cause you physical injury, I have to make retribution, and I have the ability to stand against you and show that injury. It's where the system tries to hold you accountable for frivolous, made up injuries, like smoking what you want to when you're not harming anybody, like driving safely but above a certain speed because the conditions make it safe. It's those type of extortions which bring the system into disrepute, because they're trying to have some kind of veneer of acceptability by saying that there is an injured party and that we're serving society's best interests, when if people who are robbing or people who are being violent towards other people, you know, that's really where society needs a justice system.
Exactly. I mean, the way I look at it is they call it a justice system, but I'll say we need an injustice system. We need to deal with injustice, not justice. Justice doesn't exist in that sense. You can't do you can do justice to something, I suppose, but you can't. Justice in itself, in my opinion, doesn't exist. But certainly injustice exists in that respect, because you can certainly do an injustice to somebody, but are you going to do your best to try and put it right? And by putting it right, you cannot do justice to it, because if you smash someone's car up, the best you can do is simply just compensate them for the time and money they may have lost, or you know, in monetary terms, and fix their car. But the car's always going to be fixed. You know, it's never going to be as good as it was, because obviously it's damaged it, you know, as the original. And you can't give them their time back. But all you might be able to do is give them some money. But that's it. You can't really do justice to something if an accident happens, or even if you do something deliberate or negligently. So you can never really do justice to anything in that respect. All you can try and do is just try and put it right as best you can. So you can try and do it justice, but you certainly can't create justice in that sense. That's my opinion on it, anyway.
No, I agree with that, Ben. Should we listen to James? Law James is ready to rock.
Yeah, hello.
Sorry, mate. Hello, mate. So, whereabouts are you from?
From London.
Oh, good. Oh, my part of the world. So,
Hi,
are you dealing with a bureaucratic attack?
Am I what?
Are you dealing with a bureaucratic attack at the moment?
Yeah. Well,
Okay.
it's the same. Well, I've been listening in, and this is basically the same thing as weed, man. They found some weed in my house. They took my phones and they put me on bail conditions. I've got to go back in on the 20th, and I've got to be in at 4 o'clock between 4 and 12. And I can't, if I break the bail conditions, I can go get arrested until my court case. So I'm in a bit of a situation. They got my phones and they took £300 as well off me.
Wonder where that's going to go. Hey, after this call, you'll have to get together with the other fella, and you'll have to compare notes, because anything that we can see similarities between how they treat you, we can find some opportunities to get in there, can't we, Vin? Because it's finding the right time to phone and what to fax and things like that. So keep in touch with everyone else on this show, and it'll be a lot of use.
Yeah, well, yeah.
Do you mind me asking a question, James? Was it just? I don't mean to be little. Was it just the weed? Was there no resisting arrest or anything else? That's good news. That's really good news.
So, I mean, it's just a matter of they've put you on bail at the moment, so I'll take it there's still an investigation going on.
Yeah.
And therefore, you've just got to wait for them to conclude that investigation and see whether they're actually going to bring a case against you. That's basically what you're waiting on, isn't it? I'll take it.
I just don't know who to speak to when I go back to the station about the facts.
Okay.
About the facts.
I wouldn't say a thing. If you're going back to the police station for bail, you're going there simply to have your bail renewed. If they want to interview you and try and get you to admit anything, just no comment. Give your name, details, address, that's it. And if they want to ask any details and want to get anything else out of you, no comment. Don't say a word to them. You're perfectly entitled to do that. People feel like, oh no, they're going to use that against me, and it's going to, you're under no obligation to incriminate yourself or say a damn thing to them. No comment to every question.
But as far as calling, because you've probably got a good idea, if you've heard a few of Marc's calls, what the questions you should be asking. I know it's really difficult to find somebody like a solicitor or a policeman that's actually handling the case. They seem just to rest in thin air. So that's the information we need to really get, and it's been somebody to grab a hold of and say, well, what have you got?
As soon as
that's why we're sorry. Go on.
I was going to say, as soon as they lay a charge, that will be the first thing that it would be worthwhile doing, is contacting the prosecution, whoever that may be, whoever the police have handed it on to, that have decided that there's a charge to be answered, and ask them for the evidence of that. And as soon as you can start that paper trail, you're saying, I want proof that what I did was illegal because I didn't hurt anybody. I've done nothing wrong. And until you show me evidence that I've done something wrong, then I can't take you seriously. I can't knowingly understand what it is that you're trying to do. I've done nothing wrong until you show me the evidence. And you're Mr. Prosecutor, you have the burden of proof, and that's facts beyond a reasonable doubt. When you show me the facts that what I'm putting in my cigarette, putting in my pipe, is illegal with facts, then we can consider moving on. But until that time, you can't, because you're not informed. And in this country, you have to be knowingly informed of the cause and nature of the charges against you.
Yep, absolutely, that's right. And I mean, the way to look at it is the same with any of these issues they bring against you when they're just bringing an opinion against you about what they're accusing you of. It's with you having an obligation to pay tax, income tax. You ask them, well, what is the factual difference between income and taxable income? The facts are, it's nothing more than just an opinion. There are no facts there. There is nothing else behind it. It's the same difference when they claim, well, what is the when they claim that your house is liable, for council tax because it's within a certain geographical area. Well, what is the factual difference between a house that's non-liable and a house that is? Again, it's just an opinion. It's the same thing between smoking a cigarette and smoking something they call weed. What is the factual difference between smoking a cigarette and smoking smoking weed? What is the factual difference, legally speaking? One's illegal, one's not. Well, what does that mean? It simply means it's an opinion. It's an opinion that will allow you to smoke one thing, but not another. But there's no factual difference.
People
other than it's just the opinion. One will let you, one we won't, because we say so. That's it.
Yeah, people have got under the impression like legislators and Parliament have this sort of like power to make decisions for them because they've been voted in, and it's the majority that have voted them in to gave them the power to represent and make decisions for everyone.
That's the illusion that is encouraged. But the fact is that. James, have you ever met any of those 651 legislators in the House of Parliament? Yes or no? No.
I don't even know one of their names.
Exactly. So, you have no agreement with them. And they can't factually prove you have an agreement with them. But their public relations policy is to make that so very real, especially when you're in a courtroom and they're threatening you.
The only thing I've heard is... it's because you've got a birth certificate and you accept their benefits, so you have to, I guess, like go with their rules because you're in. I don't know. But
no, it's not even that.
No, it's rubbish. So yeah. Birth certificate.
It's just if you imagine you became a policeman and then they gave you this book and it said, well, you can do this, but you can't do this. You can do this. He thinks that he can do anything he wants, and they're reasonably, supposedly, well, we all know they go over the lines, but they're supposed to ask you for consent and all that. But it's nothing to do with your birth certificate. It's the delusions that they're told amongst their group. So they take these acts of Parliament very seriously as well. So when they accuse you of breaking one, they just presume that they apply to you. But there's nothing to it. It's just a delusion.
James, in my passport, I have a passport. It says British citizen, and that's the opinion of the people who say I need this piece of paper to get around from A to B to go and visit my family, and so I have this piece of paper called a passport to humour these people so that I can go about my business, and if anybody asks me why I have this piece of paper. That's why I pay a lot of money for that piece of paper, because I humour these guys and I just want to be left alone. It doesn't prove anything, no more than having a driving licence proves that you get that piece of paper so you can be left alone to go and visit your friends and your family.
But when you sign, but you have to sign something, isn't there some sort of like hidden clause or something?
There's nothing, James. There's absolutely nothing. We can talk about it later, but we've got to hand it back to Vin now because we've only got a couple of minutes left. Nice talking to you all as well. Thanks, guys. I'll catch you all next week.
Sure,
Vin?
okay. Yeah, I'm here. So I was just going to read a bit of case law out just quickly. Regarding
We've been called on 2 minutes, so you know, Vin.
Sure, that's all right. Yep, I'll do this quick, guys. Right. Performing the functions of investigating and preventing crime, the police owe no duty of care to individual members of the public in such circumstances, even where it was reasonably foreseeable there is an insufficient proximity between the police and the victim. So, and there's other cases that basically state that the police have got no duty to prevent the criminal acts of somebody else against another. So what they're accusing you of with having weed is committing a crime against other people, and yet they have no duty to actually prevent you from doing that. So they can't claim this is being done under circumstances where they're trying to protect the public. They don't owe nothing to the public as far as they're concerned, so they can't claim this is anything to do with protection. So anyway, I'll have to end it there. We'll carry on this call after the after the show ends, and we'll add some comments and extra stuff up late for next week's show. So thanks all for listening in. This is the No State Project Reloading. I'll be back with you again next week. If you want to check my website out, it's nostateprojectuk.co.nr and markstevens.net. And we'll catch you all again next week. Thanks for listening, and bye for now.
Yeah, bye everyone.